Hi, I'm Jan Neal, and we're going to talk about the legal issues that every caregiver needs to know, or where you can find the answers to your questions. Now, I know that this is a big topic, and we're going to cover a lot of information, but understand off the top, you're not going to be tested on this. I want you to just generally know things that you need to be aware of and how to get more help if an issue comes up and you need that. I've given you my contact information, and included there is our my email and our website and where you can locate us on Facebook. And I also want you to be aware of the fact that I normally take publications like this and upload them to SlideShare, also to our website. And I believe that your area agency on aging will also make these available on some of their platforms. But you will be able to access this information, even though we're not going to go into all the detail that's on all of the slides, because I do want to leave enough time for questions to be asked if you have any. Today, we're looking at the critical issues caregivers need to understand so that they can effectively care for someone, or for that matter, care for themselves. You know, that's an important thing to keep in mind, that even though you're a caregiver, it's critical that you look out for your own issues. These are kind of threshold issues that I think every caregiver needs to be conscious of, and at least be asking themselves if they need more information about these topics. Caregiving is a hard job, and you all know that. It's hard enough without running into problems that you could have avoided if you had just had the information that you needed. And today we're going to look at 6 critical things that caregivers need to do. Get organized, understand legal authority and get documents prepared, understand retirement benefits and where to get help, plan for disabled relatives, plan for long-term care, and plan for death. This getting organized issue is something that a lot of people don't even think about, but once you get into issues where you see a caregiver trying to solve problems for the person they're taking care of, you realize just how important getting organized is. I always say you can't effectively manage property that you don't know. If you don't know something exists, you can't deal with it. And if you're going to be dealing with someone else's business matters or their medical care, then it's really important to get a handle on their financial affairs. You need to know where they have accounts and credit cards, what bills are automatically deducted from their accounts, what are automatically paid with credit cards, what bills are generated through the mail, sources of income, their insurance and health insurance coverage, their passwords, and what advance directives, wills, trusts that they may have already put in place. It's important to get control of the mail. If you don't, you might miss important notices about property tax or health coverage. You need to know what bills come in through what sources and get a handle on that. You need to find important documents like Medicare cards, military papers, marriage and divorce papers. And it's really important to do this before the person that you're providing care for is no longer capable of providing you information about where to find these things. The other day, I met with a man whose wife handled all of their business, and she suddenly died. And he was just at a loss. He couldn't get into any of their accounts. He didn't know what was paid, how, through a credit card. He couldn't even get into her email where some of the bills were coming in on a monthly basis. We were going through her phone and looking for a password app to see if there was some way to access some of this information. This is when you realize how important it is to know exactly what it is that you're handling for someone else. Understanding legal authority and getting documents prepared is really important. A lot of times, family members will be on someone's bank account and they'll say, hey, I can pay the bills. There's no problem here. And that may be true. But what you find is that when you get into specifically issues like long-term care settings, you may not have the legal authority that you need to handle what you need to handle. Like you need authority to sign contracts, to sell property, to set up income trust for Medicaid, if that should be needed, give liens to Medicaid, access money in bank accounts, and handle day-to-day financial transactions. When a person can't handle their own medical care, the medical agent takes over to make routine medical decisions. And if the person is terminal or permanently unconscious, the healthcare proxy can direct end-of-life decisions that may need to be made. A person may name an individual or co-agents to serve in any of these capacities. So it's really important to recognize that sometimes that actual legal authority on paper needs to be provided. You try to sell a house and you don't have the authority to do that, well, the deal is dead in the water. All legal authority roles involve a person naming another person to legally act for them in the event that they can't act for themselves. And all states have agency laws to define who may act for another person, but those laws vary state to state. And further, the ways that various agency authority arrangements can be made differ. And because of that, it's important to understand authority issues because it can be complicated and confusing. First, let's look at some of the documents that can be prepared to deal with these issues. The durable power of attorney is primarily for financial decision-making. You can also include in that document a healthcare directive, or if you want to have just financial decision-making in your durable power of attorney, you can make a separate healthcare power of attorney, or you can give powers to handle medical decisions in an advance directive for healthcare. You can make end-of-life decisions or direct somebody to make end-of-life decisions also through a durable power of attorney, or you can put that in an advance directive for healthcare. Other possible documents that you may need is a last will and testament or a trust. And it's important to look for proper beneficiary designations so that if someone dies, the money in a particular account goes to who they would want it to go to. And another document that can be prepared is the affidavit for disposal of remains. Every now and then you'll run into situations where there's a dispute in a family about whether a person should be cremated, or particularly like in second marriages, you may find that one side of the family wants someone to be buried in one location and another side of the family wants someone buried somewhere else. So you can name someone that has the authority to make those decisions for you, and you can give specific instructions on what you wanted for your disposal of remains. Now, I've provided you a link to our website where there is an ebook titled Guide to Alabama Advanced Directives. There are several on our website about advanced directives. And there's also an ebook, A Guide to Planning for Death. Let's look a little closer at the durable power of attorney. I often say that it's the most flexible and least expensive way to get authority to conduct financial business for another person during his lifetime, because you can make this document actually read the way you want to in terms of who you name. You can name one person to handle one power, another person to handle another, and it's important to look at who all you're naming into these roles. Understand that the person who makes the document is called the principal, and the person who receives the power to act for them is the agent. It's also for financial affairs, the person can be called the attorney in fact. For healthcare powers of attorney, that person is an agent to make routine healthcare decisions, and a healthcare surrogate is an agent to make end-of-life decisions. Now, it's extremely important to understand that these powers can only be given while the principal is still competent to give that authority to another person. In this way, powers of attorney require pre-incapacity planning, because once a person is suffering from significant incapacity, a power of attorney can't be signed. And if one is signed, the power given can be challenged by other people who may not want the power to be given to that particular agent. The capacity created to create a power of attorney is the same level of capacity needed to sign a contract, because the maker of the directive must decide if he wants the agent to handle highly specific powers. Sometimes you see people who have early diagnosis of cognitive impairment, and they're still intact to make a power of attorney. At other times, you see that people may be a little too far gone to do that. When there is a questionable request for a power of attorney, we have a form that we can provide to the doctor who treats that patient on a regular basis and knows about their capacity issues. And this is essentially what I'm showing you here is a request for medical opinion concerning capacity. And it explains that due to the complex and comprehensive nature of the Alabama Uniform Power of Attorney and the potential for exploitation through the use of a power of attorney, it's important that the person executing the document have a high enough level of capacity needed to execute that contract or that document, as high as if they were executing a contract. As such, the maker of the document must have the current ability to receive and evaluate information and make and communicate decisions demonstrating the ability to manage property or business affairs. So you can see that a person may be able to handle some things, but they might not be able to handle other things. So we're looking for generally a person who is intact enough to handle the powers that they're giving away. Originally, the durable power of attorney required that there be specific language in the document indicating this power of attorney shall not be affected by disability, incompetency, or incapacity of the principal, or language like that, to survive the incapacity of the person who made the document. This particular language remained a requirement in the law in Alabama until the Alabama Uniform Power of Attorney Act passed and became effective January 1st, 2012. Now, this may be kind of confusing to you because nobody thinks about anything but a durable power of attorney today, but originally powers of attorney went out of existence when a person lost the capacity. And so along came the durable power of attorney. How durable? Durable enough to survive the incapacity of the principal. And that's why we had to have this particular language in there. This power of attorney shall not be affected by disability, incompetency, or incapacity of the principal. What happened as of January 1st, 2012 is that the law eliminated that language requirement, and it's presumed that powers of attorney signed in Alabama after that date are durable. So before 2012, it wouldn't be durable without that language, but as of January 1st, 2012, it is durable. Now, understand that this is important distinction to recognize. Whenever you're looking at a power of attorney, you're looking at when it was signed. And if it predated January 1st, 2012, it's important to find that specific language in the document. And if the document was signed on or after January 1st, 2012, then you don't have to worry about that language being in the document. The Alabama form power of attorney is a little confusing in the way the powers are laid out, or at least I find it to be. There are general powers that a person gives by signing just his signature, that he wants that document to include all those powers. And then there is a section that indicates the agent cannot perform certain acts unless the person making the power initials those specific items. This can get kind of tricky, and I think people get confused with it. So a lot of times attorneys will just spell out all of the powers in the document without a specific need to initial the prohibited powers. I know that that's the way I prefer to do it. Something else to realize that there is no HIPAA personal representative to access medical records named in the standard form. So that should probably be added to a durable power of attorney. Powers included in the durable power of attorney are very broad, and they include real property, tangible personal property, stocks and bonds, commodities and options, banks and other financial institution, operation of entity or business, insurance and annuities, estates, trusts, and other beneficial interests, claims and litigation, personal and family maintenance, benefits from government programs or civil or military service, and retirement plans. Usually people just sign their signature and the agent has authority over all of these particular issues. The excluded powers, unless selected, include to create, amend, revoke, or terminate an inter vivos trust. That's a living trust created during life rather than a testamentary trust created in a will. Create or change rights of survivorship. Create or change a beneficiary designation. Delegate authority granted under a power of attorney, which means name a successor financial agent. Sometimes your agent might become very sick, might go out of the country, might be in a position where they can't serve at that particular time. And in a power of attorney, you can actually give your agent the ability to delegate their power to someone else when they're not able to act. Then waive the principal's right to be a beneficiary of a joint and survivor annuity, including a survivor benefit under a retirement plan, and exercise fiduciary powers that the principal has authority to delegate. Normally, like I said, we'll put all of these powers in the power of attorney. I kind of have this feeling that if you don't trust the person that you're naming, you really shouldn't be naming them. And if you do trust that person, I think that you want to give them the ability to handle all the things that they may actually need to do to protect you. The Act says that a power of attorney must be signed by the principal or in the principal's conscious presence by another individual directed by the principal to sign the principal's name on the power of attorney. So technically, say a person's paralyzed, they could say to someone else, sign my name on this document. And now while that can be done that way, I don't really recommend it. Then it becomes a question of fact. Did they really give somebody the authority to do that? I think it's better for the principal to make a mark, even with the help of another. And we've done that in our office where someone has a very shaky signature. They can barely hold the pen. You can hold their hand while they make their mark. When any legal document is signed, the witnesses and the notary should not be interested parties. That means don't take your relatives with you to sign a power of attorney to be the witnesses. It shouldn't be people that would inherit under your estate. It shouldn't be the actual caregiver. Powers that were created on and after January 1st, 2012 should be notarized to be considered valid. Let's look at some practical considerations about powers of attorney. It's important to name an alternate in a power of attorney so that a person is designated to serve if the primary agent should die or become incapacitated to serve. Now, this is really an important concept. And a lot of times when I'm working with caregivers, I say, well, what about your power of attorney? You know, your husband named you and you named your husband, and your husband is now disabled to serve. Do you have an alternate in your power of attorney so that if something suddenly happened to you, you would have someone who could look out for you? This is important for everybody to keep in mind, but I think it's particularly important when you realize that a lot of times the person you name to be your agent is the person that you're now caregiving. An agent should always sign the name of the person that they're looking out for by themselves as the attorney in fact. For an example, so let's say that John is signing a nursing home admission contract for Mary. He would sign Mary Jones by John Jones as agent or power of attorney. Or maybe Mary Jones by John Jones as attorney in fact. This is an important point to keep in mind to prevent the agent from incurring personal liability. It's making it clear that he or she is signing in a representative capacity. Don't go putting your name first. Never say John Jones as agent for Mary Jones. You want Mary's name to be first on that contract or on whatever's being signed so that you realize that Mary is actually the signor. Now, a power of attorney does not need to be filed with the court unless there will be a real estate transaction performed by the agent under authority of that power of attorney. Say you're selling someone's home and the agent, the person named in the power of attorney, is actually making the sale. In that case, that power of attorney needs to be of record in the probate court where that property is being sold so that you have a clear chain of title and authority to do that financial transaction. But otherwise, it's not so important that the power of attorney be filed with the probate court. An advance directive goes into effect when it's signed, unless it's what's called a springing power of attorney, and powers of attorney end at death or when they're revoked. Now, a springing power of attorney is something I really don't recommend. I've seen problems with these. Sometimes people will say, I name so-and-so to be my power of attorney when I become disabled or incapacitated. That means that you have to prove somebody has become disabled or incapacitated for the document to take effect. The other day, I was working with a man whose mother is in hospice and is very ill. She had a springing power of attorney. We needed to spring that power of attorney so that he could act for her. He went to the doctor asking for the doctor to state an opinion, to give a medical opinion about her capacity to attach to the power of attorney, and the doctor wouldn't do it. And I found that just absurd. But the man, I said, well, maybe you need to tell the doctor that if he wants any decisions made, he needs to get those decisions made by talking to your mother, who really wouldn't be able to do that. But these are the kind of problems that you run into when you have a springing power of attorney. The agent needs to be able to act as soon as possible, and you don't want to go through a lot of administrative hassle trying to get someone to document that this person does have an incapacity. Now, I want to look at a couple of other documents that I'm sure you recognize, and maybe some of you have. The first is a living will. A living will does not name an agent. The Alabama Living Will came into the law back in 1981, and it only allows a patient to give the physician instructions concerning artificial life-sustaining procedures that should be used if the patient should be terminal. Originally, in that document, there was no authorization by Alabama law that would allow the patient to give instructions if he or she should be in a persistent vegetative state. Even though Alabama law advanced over the years to provide agent designation, the old living wills were grandfathered in, and a lot of people still rely on that very limited authority as basic direction to a doctor. Now, I'll tell you why this is a very ineffective thing to do. A living will is a document that you sign and you give to the doctor to put in your file. Well, the problem is a lot of times, by the time someone dies, that doctor is not the treating physician. A lot of times the doctor treating someone at end of life is a specialist, or it might be that along the way that doctor retired, and along with all of his other records, off went your advance directive known as a living will. I just don't think they're very effective, but they are still, like I said, grandfathered in. The advance directive for health care came in 1997, and it amended the living will. It indicates the treatment and food and hydration preferences a person has if he or she should be terminal or permanently unconscious. An agent called healthcare proxy can be named in the document with a designation that they should follow only your wishes, or they can address issues not addressed in the form, or they can make final decisions, even if those decisions differ from what you said you wanted on the form. If you decide that you want an advance directive for healthcare, you would still need a separate power of attorney to handle financial decision-making. I'm not a big fan of the advance directive for healthcare. I have seen people selecting the healthcare they want, and that might not go into effect for 10 or 15 years. And we don't even know what medical treatment will be like at that time. I think it's much more effective to name an actual person to talk to a doctor and get all the facts before making a decision. Now, there are other authority granting documents that I just want you to be aware of. You may never run across a certification of healthcare decision surrogate. I like to call this the self-appointed agent form, but it is a procedure allowed under Alabama law when somebody did not make an advance directive, and a person can step up and say, I want to be named as the person to make these decisions. This is generally in a situation where it's end-of-life decision-making. The line of priority for appointment as a self-appointed surrogate is a court-appointed guardian, the spouse, an adult child, a parent, a sibling, other next of kin, or even the ethics committee for a facility. The person that's asking to be appointed has to show that nobody higher up in the line of appointment wants that job, and that there's been no advance directive that was made, and essentially that there's nobody else who can serve in this position. Now, recognize that even if a facility should accept that form, they're probably not going to take directions from that agent about making end-of-life decisions without it going before a court for court approval. Agencies can also actually appoint people to handle their benefits, such as the Social Security representative payee and the VA fiduciary. Another term you'll hear is sponsor. I want you to be aware of the fact that sponsor is a form used in the long-term care industry, but a sponsor, and that's the person that the nursing home will call if there's an emergency. But a sponsor does not have legal authority in any manner. The Alabama Medicaid agency will actually use the term sponsor and let that person apply for Medicaid. But again, that is not really legal authority, and a sponsor can't sign a lien to Medicaid, and a sponsor can't sell property. So that's an important thing to know. Also recognize that whenever Social Security names a representative payee or the VA names a fiduciary, that person only has authority over those particular benefits and not in any other capacity. A do not attempt resuscitation order is something that can be signed by a doctor instructing that resuscitative measures not be provided to a person if that person is found to be in cardiopulmonary cessation. DNARs can be issued either with the consent of the patient if they're competent, or pursuant to instructions in an advance directive if the patient is not competent and is no longer able to understand, appreciate, and direct his or her medical treatment, and there isn't any hope of regaining that ability, or with the consent of a healthcare proxy designated under the Natural Death Act. This is the end-of-life decision maker we've been talking about, or at the instruction of an attorney, in fact, under a durable power of attorney that grants the agent the power to make end-of-life decisions in accordance with the Natural Death Act. Now, for many years, DNARs were made in individual facilities. And like you might see somebody go from a nursing home to a hospital, leave the hospital, go to a rehab facility, leave the rehab facility, go back to the nursing home. And each time a DNAR would need to be signed because those DNARs were only recognized in that individual facility. But in 2016, Alabama created what's called a portable DNAR that can be used across multiple healthcare settings. Now, in order to be portable that way and go from facility to facility, that form must meet the requirements of law to make it portable, provided it by a form provided in the State Board of Health Administrative Code. You might still see forms that are particular just to a given hospital, but very often you will see that portable DNAR. Now, if a person does not make an advance directive while they still have the capacity to do so, and some action needs to be taken by the caregiver, there's really very little that you can do except take it before the probate court to have a guardian appointed. The probate court can appoint a guardian to have authority over the body of an incapacitated person, and that is to decide where the person lives, medical treatment, things of that sort. And the standard you have to meet to find a person to be incapacitated is you have to show any person who is impaired by reason of mental illness, mental deficiency, physical illness or disability, physical or mental infirmities accompanying advanced age, chronic use of drugs, chronic intoxication, or other cause except minority, to the extent of lacking sufficient understanding or capacity to make or communicate responsible decisions. The law gives a list of people who are top priority to be appointed the guardian, and they include a person named in a durable power of attorney, a spouse or spouse's nominee, the adult child, parent or the parent's nominee, a relative with whom the person has lived the prior 6 months, and a nominee of the caretaker of the person. Now, what about finances? You know, the guardian only has authority over the body. To have authority over finances, the court can appoint a conservator. And very often you'll find that courts do appoint the same person to be the guardian and the conservator, but in some circumstances, the court will split those jobs and name one person to be the conservator and another to be the guardian. The only requirement would be that they have demonstrated that the two can work together well, because it's fine to make a decision about where someone lives, but you need the person paying the bills to be on board with that decision. In order to find that a person is in need of protection, the standard to meet is that they are unable to manage property and business affairs effectively for such reasons as mental illness, mental deficiency, physical illness or disability, physical or mental infirmities accompanying advanced age, chronic intoxication, confinement, detention by a foreign power, or disappearance, and whose property will be wasted or dissipated unless property management is provided, or for whom funds are needed for the health, support, education, or maintenance of the person or of those entitled to the person's support, and that protection is necessary or desirable to obtain or provide the funds. Now, for a conservator, the list of people in a priority position to be named include conservator appointed in another jurisdiction, a person selected by an incapacitated person, the person designated by incapacitated person's power of attorney, the spouse, adult child, parent, relative with whom that person has lived the last 6 months, nominee of the person caring for the incapacitated person, or the general guardian or sheriff. Now, some counties actually have a county conservator, but counties that don't, the sheriff actually ends up in the position of being the conservator. Now, besides attorney's fees and filing fees, the court is required to appoint a different lawyer to serve as the guardian ad litem to represent the person who may need a guardian or conservator. That person can decide whether to concede, yes, my client needs a guardian or conservator, or to fight the appointment. Obtaining a court-appointed guardian and conservator takes time and it takes money. You have filing fees. You have to be bonded on the value of the estate, and you have to account to the court at least every 3 years for all income and expenditures. So you can see why it's a much preferable thing if you can get someone to prepare a durable power of attorney that includes all the powers needed to keep this from being an authority arrangement that's reviewed by the court and accountings that have to be done on a routine basis. The legal assistance program is available through your Aging and Disability Resource Center, and that service can help you with legal issues related to advance directives. My firm is currently the legal assistance provider, and you can contact us either through the Aging and Disability Resource Center or reach out to me directly at the phone numbers provided in this presentation. The third issue to look at is understanding retirement benefits and where to get help. Whether you're dealing with your own self or the person you're taking care of, it's important, first of all, to recognize that if you apply for Social Security disability and you get it, you'll have a source of income. But Medicare coverage will not begin until 2 years after qualification for Social Security disability. To get maximum Social Security retirement benefits, a person should not draw before reaching full retirement age. Now, what is that? For people born in 1937 and earlier, the full retirement age was 65. It was very easy back then to understand that you'd get Social Security and you'd get Medicare at the same time. But over the years, the full retirement age has been creeping up, and so it's a little more confusing. people born after 1937, the full retirement age varies from age 65 in a few months to age 67. So it's important to know, because drawing benefits before that full retirement age will result in a decrease in the benefits for life. A person who draws early retirement at age 62 will have as much as a 30% loss of benefits. Now, persons who have not reached full retirement age but continue to work and they drew early will have what's known as a potential offset of their Social Security, which seems crazy to me. You know, what's the use of drawing a benefit to then have some of it taken away from you? But I guess sometimes people have to piece things together as best they can to meet their bills. Now, for earnings greater than $19,560 a year, which is $1,630 a month, a person with the offset will lose $1 in benefits for every $2 earned over $19,560. That $19,560 is the amount for 2022. That will change again probably in 2023. Now, for persons who reach full retirement age during 2022, the earnings that predate reaching full retirement age have a less severe offset. In that event, the person will lose $1 in benefits for every $3 of earnings over $51,960 for the year, which is $4,330 per month. Now, you can apply for Social Security 4 months before the date you plan to draw, say 4 months before you hit full retirement age. Application online is actually a lot easier than going into the Social Security office. Timing is really important when you apply for Medicare. Medicare is married to the age of 65, not the full retirement age of Social Security. So recognize that a lot of people go on Medicare at age 65 and they're continuing to work and they're not getting Social Security yet. So if you're not getting Social Security yet, your premiums are paid because Medicare will notify you that you need to pay them, and you can pay them quarterly until you get on Social Security. At that point, your Medicare premiums are pulled out of your Social Security check. Now, most people do know that A is for hospital coverage, B is doctor coverage, C is a Medicare Advantage, which is managed care plans, and D is for drug coverage. And when you do first apply for Medicare and on through the years, you have to decide if you want to select between original Medicare or if you want a Medicare managed care plan, Medicare Advantage. Now, nobody, like I said at the beginning, is going to test you on this, so don't get nervous about all this. But do know that there are deadlines that you need to meet in your application for Medicare. For your initial enrollment, it's 3 months before you turn 65, the month you turn 65, and 3 months after you turn 65. You must enroll during that 7-month period to keep from having penalties. Open enrollment happens every October 15th through December the 7th every year, and that's when you can change your coverage. There are things called special enrollments, and that's when you lose coverage or you enter a nursing home, or say your plan goes out of being offered in your county. It's also a special enrollment. If you continue to work, you have 8 months after leaving employer coverage to get in Medicare. Then there's general enrollment. That's every year between January 1st and March the 31st, when you can sign up if you missed your initial enrollment period, but then you're not going to get coverage until July. Medicare open enrollment is every January 1st through March 31st, when you can switch or you can leave a Medicare Advantage plan. Medigap open enrollment is 6 months after the age 65, and you're enrolled in B. You can't be denied or charged higher premiums for pre-existing conditions. So it's important to recognize that when you do get on Medicare Part B, you really need to move on getting a Medigap policy. And then there's this thing called a 5-star special enrollment. Plans are ranked by stars based on the satisfaction of people who are in the plan. And there are some 5-star plans that mean people really like those plans a lot. And if you want to switch to a 5-star plan, you can do that once a year. There are penalties for late enrollment, and you're going to pay higher premiums if you're late enrolling. For Part B, there's a 10% of the regular premium for every 12 months you're unenrolled. Now, the premium is $170.10 in 2022. So the penalty is $17.01 for each 12 months that you're late enrolling in 2022. Now, it's not just this year. You're going to have that 10% of the national premium every year for life. So it's a severe penalty. For Part D, you get 1% of the national base premium, which is $33.37 in 2022 for each month unenrolled. So the penalty is $4 a month for each month you're late enrolling in 2022. This can add up. So it's really important to keep your eye on the appropriate time to apply for Medicare and not incur a penalty. I want you to be aware of what an IRMA is. It's an income-related monthly adjustment amount. You'll pay more for Medicare premiums if you have higher income. The government looks at income for the prior 2 years to determine if you should pay a higher premium. For 2022, you pay the standard Part B premium of $170.10 for income at or less than $91,000. But for earnings between $91,000 and $114,000, the premium goes up to $238.10. There are tiers for different income levels, and the cap is $578.30 for income at or over $500,000. There are also IRMAs for Part D. In 2022, you pay the Part D premium based on the plan you select for income at or below $91,000. But for earnings from $91,000 to $228,000, you pay the premium for the plan you selected plus an additional $12.40 a month. And there are tiers for different income levels, and it caps out at your standard premium plus $77.90 for income at or over $500,000. If you need help with Medicare issues and getting enrolled or having claims paid or anything of that nature, comparing plans, finding out what's available in your area, deciding if you want to stay in original Medicare or if you want a Medicare Advantage, you can contact the state health insurance program that's available through your Aging and Disability Resource Center. That service can help you maneuver through the maze of Medicare. All I want to do today is get you to be aware of the issues that you need to move at particular times and don't put it off. The Legal Assistance Program is available through the Aging and Disability Resource Center, and we can help you with public benefits and income security. The fourth issue is planning for disabled relatives. Now, I'm not going to get into a lot of detail on this because it is pretty complicated, but I just want you to know that people who are on SSI and Medicaid, which are what's called means-tested benefits, these people can only have so much income and so many resources and still qualify for those benefits. There is a tool that you can use known as the Special Needs Trust, which a person can have money in a special needs trust without losing their SSI and Medicaid. Very often, you see situations where a person might be inheriting money, and they're on SSI and Medicaid and they don't want to lose their benefits, that money can be put into a special needs trust. You see grandparents who want to provide for their grandchild who's disabled, and they might make a will and say that their personal representative should establish a special needs trust for that child. Or a person over 65 needs to spend down a certain amount of resources in order to qualify for Medicaid in the nursing home. Instead of just spending that down month after month, that money can be put into a special needs trust, and it provides funds that will pay for a private room in a nursing home, because, you know, Medicaid will only pay for a semi-private room. It will also provide a pool of money from which sitters can be paid if a person needs sitters in a nursing home, or any equipment or anything that Medicaid won't pay for. Now, some of these trusts do have what's called a Medicaid payback. And if the money ever belonged to the person that is on the means tested benefits, then there is a Medicaid payback, where if anything's left in that trust when the person dies, Medicaid can get dollar for dollar what they paid for someone's care, a reimbursement. Some trusts are what's called third-party trusts, like the grandparents who wanted to give money to grandchildren. It was the grandparents' money. It never belonged to the grandchildren. That would be considered a third-party trust, and there's no Medicaid payback on that. In the materials, I've given you a list of the different things that money in a special needs trust can be used for. And I encourage you to get this PowerPoint and look at that if you're at all interested in setting up a special needs trust. Plan for long-term care. This is incredibly important. The average cost of care in a nursing home right now for a private room is $7,026, and for a semi-private room is $6,676. I've given you the cost for regular assisted living, adult daycare, homemaker services, and home health aid. And you can see that long-term care is very expensive. The payment options are limited. You can privately pay. You can have long-term care insurance. Medicare will pay a tiny little bit, which is not much at all. They'll pay for 21 days in a nursing home after a 3-day stay in a skilled care, and when skilled care is ordered after 3 days in a hospital. But the copayment kicks up to $194.50 a day on day 21. So you can see that's not much coverage. Medicaid pays for most long-term care in the state of Alabama. The most you can set aside for a spouse at home is $137,400. And the most you can send home from the Medicaid applicant's income to help the spouse at home is enough to bring their income up to $2,289. It's really important to recognize that Medicaid looks back for 5 years to make sure that nothing was given away during that 5-year period. When you sell property, you need to sell it for the tax assessor's appraised value. If you sell it for less than that, that would be considered giving part of it away. It's important, if you're a family caregiver, that you need, and you get paid, that you have a caregiver agreement in place. The legal assistance program offers a lot of assistance with long-term care. And there is there are a number of publications at our website about getting ready for long-term care. And I encourage you to look there if you want more information. Now, the last issue is plan for death. You need to be sure that beneficiary designations are current. Make sure that you don't have a spouse who died years ago still as your beneficiary on an IRA or something of that nature. Make your will or create a living trust. Make prepaid burial arrangements, and If you think there could be some problem in your family about disposal of remains, make an affidavit concerning disposal of remains. One issue about that I do want to make is that if you're a couple and you're not married and you want to be cremated, it's important to have that affidavit, because the person who is not your next of kin will very often not be allowed to give instructions for a cremation. I don't know what that's all about, but I think it's because if there's a burial and it's done wrong or without proper authority, then a person can be exhumed. But if there's been a cremation, there's no way to correct that act being done without proper authority. So a lot of funeral homes are very cautious, and they will actually go over the head of the person that you name to handle your will. And they'll ask for a next of kin relative to sign to have a person cremated. You can visit our website at www.janneallaw.com. And I've also given you a link to our Facebook page. You can go to our website and you can find lots of articles, ebooks, and presentations on the topics that we discussed in this presentation today. And I want you to feel free to get in touch with me if there's any way that you think I can help you with any issues that you're having. We're going to conclude the program today, and I'll be happy to answer any questions that you may have. So don't hesitate to get in touch with me.